Oh, I'm sorry. We'll wait for Mr. All right, we are on the record in file 23-21319-FH Keegan Preston, People versus Keegan Preston Ferguson. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Rhonda Underwood for Mr. Ferguson this morning, Your Honor.
And Ms. Underwood, where do we stand with Mr. Ferguson's case today?
Your Honor, thank you. Today, Mr. Ferguson, I believe, is going to, as part of a plea bargain with the prosecution, Your Honor, Mr. Ferguson is going to enter a plea as charged with no supplements in this matter, Your Honor. And then we've agreed to adjourn sentencing for a couple months, Your Honor, to allow Mr. Ferguson some time to get work and start making payments, Your Honor.
So, Your Honor, it's my understanding he's pleading guilty as charged. There's no habitual enhancement. We're going to ask you to set the sentencing date out like 60 days. If he's paying between now and sentencing, then I would recommend no upfront jail.
Is that a complete and accurate statement of the agreement, Ms. Underwood?
That is an accurate statement, Your Honor.
Okay, Mr. Preston or Mr. Ferguson, would you raise your right hand? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Keegan Preston Ferguson?
Yes.
Mr. Ferguson, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, failing to pay child support?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Ms. Brenner?
That's correct, Your Honor.
Ms. Underwood?
Yes, that's correct, Your Honor.
Is that also your understanding, Mr. Ferguson?
Yes, Your Honor.
If a plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent at trial, not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ferguson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, the conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 1st, 2020 through August 31st, 2021 in the city of Adrian, County of Illinois, that you did commit the offense of failing to pay child support?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Ferguson to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Ferguson, other than as we've discussed it on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Underwood, do you want to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Ferguson, as a result of a circuit court case number 218045-142 DM, you had a child support order, correct?
Yes, Your Honor. Yes.
And that was in this city of Adrian, county of Lenawee, state of Michigan, correct?
Yes.
And that was to pay for your daughter, Jordan May Ferguson. Is that correct?
No, that's to pay for my son, Quentin Gregory Ferguson.
Okay. Okay.
Jordan's his ex-wife.
Oh, I'm sorry. And during the period of August 1st, 2020 and August 31st, 2021, you did not make those payments, correct?
That is correct.
And the outstanding arrearage as of 10/26/21 was $9,154.53. Is that correct?
Yes.
I believe I've established the facts, Your Honor.
People are satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
It has, Your Honor.
All right. I'll accept the plea. It's been given knowingly, understandably, and voluntarily. The defendant has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for let's go with November 16th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Ferguson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. I'm going to put you in a breakout session real quick with Mr. Jones from the probation department. He's going to get your contact information from you.
Okay. Yes, Your Honor.
Okay. Ms. Underwood, are you ready to proceed with Mr. Wiedenbeck?
I am, Your Honor. Thank you.
Thank you. Okay, we're on record in file 23-21517-FH, People versus John Thomas Wiedenbeck. We are here today for arraignment in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Wiedenbach this morning, Your Honor.
Okay, and sir, you are John Thomas Wiedenbeck? I'm sorry, sir, the jail device is muted. I'm going to send you a request to unmute that. Okay, again, sir, you're John Thomas Wiedenbeck?
Yes, Your Honor.
Ms. Underwood, does Mr. Wiedenbeck wish to have the information read?
We would waive the reading of the information, Your Honor, acknowledge its receipt and the receipt of the request for discovery and witness list in this matter, Your Honor.
All right, how does Mr. Wiedebeck wish to proceed today?
Your Honor, Ms. Brunner and I have had some discussions regarding Mr. Wiedenbeck, and I think it's appropriate in this case to have a very quick plea trial, and I believe we'll be able to resolve this matter.
Okay, what do you mean by very quick?
Next available, Your Honor, like, I don't know,
Do one in 2 weeks on September 27th.
that would be great.
All right, September 27th at 8:15 a.m. We'll set it for a pretrial on that day.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Wiedebeck, you can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Okay.
I believe that concludes my docket with you this morning, Your Honor. If you need anything, I'll be in the other court.
Okay, thank you, Ms. Underwood. Mr. Ferguson, you are all set. You can go ahead and log out.
All right, have a fantastic day.
Thank you, you too. Mr. Daly, I do not have Mr. Mulholland here. Is he at your office, or you'll need to unmute Mr. Daly?
I have him right here with me, Judge.
Oh, okay. I apologize. Do that one.
Mike, come on back.
Okay, we're on the record in file 23-21438-FC, People versus Michael Sean Mulholland. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold.
Ellison Arnold to the people.
James Daly on behalf of the defendant, Your Honor.
Okay, and Mr. Daly, where do we stand with Mr. Mulholland's case today?
Your Honor, I had a meeting yesterday with the prosecutor on this case, and we've agreed to ask for a Cobb evaluation in an attempt to get this matter resolved.
Perfect.
All right.
Applied to it, but
How much time do you think you're going to need for that discussion?
I'm ready whenever the court and whenever the prosecutor's ready, Your Honor.
If you have any time available this afternoon, I have one thing at, I believe, 3 o'clock. At 3:30, I could do it anytime before 3:30 this afternoon.
Judge, I'm available.
I'm available too, Your Honor. Is that in person or by Zoom?
Your preference, it doesn't matter to me.
Doesn't matter to me.
Or we can come over in person.
Okay.
That'll be fine.
You want to say 3 o'clock then? Does that work?
That's fine.
good, Judge.
Okay, so I will see you then at 3 o'clock.
Thank you.
Should we set another pretrial date?
Oh, yes, we should. So
I think.
how
we
about
can-
October? How about October 4th at 8:15?
That's good.
That's fine, Your Honor.
Okay, Mr. Daly, could your office prepare a stip and order?
Yes, Your Honor.
Okay, anything else we need to address in this case today then?
No, Your Honor.
Your Honor.
All right, thank you. Then you're all set.
Thank you, Judge.
Jalen Jamal or Rosemary Hardnett? Okay. Yes, she's in the hallway. I said yes. All right, we are on the record in file 23-50919-PH. Rosemary Hardnett versus Jalen Tatum. We're here today for a hearing on an order to show cause related to an alleged violation of personal protection order. Ma'am, you are Ms. Hardnett?
Yes,
Okay. Mr. Tatum is not logged into the Zoom session and he is not present as far as I know here in the courtroom. Mr. Tatum?
he's not here.
I'm sorry, it's Mr. Jamal, not Mr. Tatum.
No, his name is Jalen Jamal Tatum.
Okay,
His last name's Tatum.
all right, I apologize. It's been written down wrong on our file, so we'll get that changed. So Mr. Tatum is not present. Ms. Hardnett, in my review of the file, it looks like you are alleging that Mr. Tatum violated the personal protection order on August 8, 2023. Is that
Yes, I have videos.
okay? It also appears from the file, the proof of service that was filed by the person that served Mr. Tatum with a copy of the order says that that was served on him on August 11 of 2020.
I know we served him at the Adrian Library. He was on a computer.
Okay. So my issue with your case is that at the time that you say he violated the order, Mr. Tatum had not been served with a copy of the personal protection order.
No, I have two. There's two here. This is this one, the first one was August 8th, 2023. That was the PPO.
Okay, that's the date. That's the date that the personal protection order was issued. That's the date I signed the personal protection order.
Yes, and then he violated.
Okay, so
This is the other one.
I understand. But what you're saying is that he violated it on August 18th. I'm sorry, that's an 18, not,
That's 17. I mean 18. Let me look here.
all right,
Let me see. Oh, it says 11/18.
okay.
That's when he was found. I have videos that he was checking my bag.
I understand that.
Um,
But if you look at the proof of service that shows when Mr. Tatum received a copy of the order, that happened on August 11th.
2 minutes before I brought it back here, yes. It was like 3 something, and I came straight here and gave it to
Okay,
the
so
lady.
the issue is your alleged violation occurred before Mr. Tatum had a copy of the order
He had a PPO. We served him a PPO.
on August 11th.
Hmm,
That's what your document says.
okay, let's see. don't need to see that part. I don't have that part. Because they didn't sign it. I gave all my papers, those papers to the lady.
Okay, so I'm looking at your proof of service that says when the personal protection order was served on him, or he was given a copy.
He was given a copy, yes, sir.
And that-
And 2
that-
days later, he violated.
That's not what your documentation shows. Your documentation shows that he was served on August 11th. Your allegation in the motion for that he violated says that he violated it on August 8th. That would be before August
I
11th.
say August 18th.
Well, that's the date of the hearing.
I ain't never been through this.
I understand. I'm just trying to explain to you that I can't hold Mr. Tatum in contempt for violating a personal protection order if he had not been served with the personal protection order when he did what you said he did.
He was served with the order, sir. With the first order, he was served by McGill. McGill served him. He was walking down the street, Michigan Avenue, and we served him. I followed McGill in my car. We served him in the middle of the street. 2 days later, this man came to my back door, checked my back door. I have videos, stole out of the lady's car. I have videos. And then I filed, came back and filed this violation because he violated by coming by my house. He came to the church. He came to the Daily Bread while I was there. I didn't put all that on there, because those are public places and I didn't put those on there. But Jalen knew he was not supposed to be around us. He's been raping people and doing all that stuff.
Just give me a moment.
Okay. I'm not understanding. I see what you're talking about.
Okay,
It says-
so I think I'm confused now. So what date was it that you're saying that he violated the order?
It says 11:18. It says PM. It's not a date. It says 11:18 PM. I didn't put a date on here for that, but it was 2 days after I served. He got served with the PPO. I had to pay one guy one time and one guy another time.
All right.
So 2 days after I filed the PPO, he violated. My landlord called me and told me he violated and showed me videos where he violated. So I recorded the videos, and then the next day, I believe I went and filed. Oh, it was the same day, because we called the police and everything. They said they couldn't do nothing.
Okay, so I think I've misread what you have in your petition. So
Those are times that he was there.
all right, and you're-
Instead of me putting the date, I'm sorry.
okay, so you're telling me now that this occurred after he was served with personal protection order?
Yes, sir. After the first, that's what the policeman told me. I had to go violated PPO. That's what he told me. I said, how come I have to do it? Isn't that your job? He said, no, we don't do those things no more. So I had to go and file another one because he violated. And we served him. He knows he's supposed to be here. And
All right. I apologize for that confusion. So Mr. Tatum was directed to be here to respond to the show cause for the alleged violation of a personal protection order. He was ordered to be here this morning at 8:15 a.m. File does contain proof of service of the personal protection order on August 11th. I understand now that these alleged violations are alleged to have occurred after August 11th. So Mr. Tatum has failed to appear here in court today as directed by the order to show cause. Based on his failure to appear, I'm going to issue a bench warrant for his arrest. I will set bond on that bench warrant at $10,000 cash or surety. And Ms. Hartnett, we will proceed when he is picked up on that warrant.
Thank you so much. Thank you.
All right. Again, I apologize for the confusion. So we're all set for today. That's as much as we're able to accomplish today. Thank you. All right, Mr. Glazier, are you ready to proceed with, or do you need a breakout session with Mr. Scroggins?
Yeah, yes, I do, Your Honor.
All right, give me a moment and I will set that up for you. Oh, yeah. Thank you. Okay, all right, we are on the record in file 23-21415-FH, file 23-21416-FC, and file 23-21417-FH, People versus Levi Max Scroggins. We are here today for pretrial hearings. In each of those cases, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazier on behalf of Mr. Scroggins.
Okay, Mr. Glazier, where do we stand with Mr. Scroggins' cases today?
I think we're going to ask that these matters be set for a trial. Mr. Scroggins is upset with me, and I guess he wants to say some stuff on the record, and that, that's up to him.
Yes, I do. Absolutely. First and foremost, am I allowed?
Go ahead, Mr. Go ahead.
Okay. First and foremost, I'm going to step in as a third-party intervener because I'm being railroaded by my own attorney here. He clearly, the witness was committing perjury downstairs. Mrs. Arnold here, she violated my constitutional rights by going past my 14-day guideline. She knew it then at the time when she went to go read the book, okay, her little law book, and just smirked at me in court then, okay? Everybody in the courtroom knew that this girl was lying. It was clearly a lie. I gave Mr. Glazier the numbers to look up. The articles of facts would be to swear or not to swear document signs, default notaries of public, and proposal to abolish oral notations. And the numbers on that is 50 Buffalo L reference number 613. At the time I gave Glazier the numbers, he just waved me off as he coerces me as usual. Okay, that's your numbers to prove that, to follow up on what I'm saying has veracity. Okay. Let's see here. Yeah, the unexplained delays in trial and prosecution are arbitratable to the state for the purpose of determining denial of constitutional right of speedy trial. People versus Bennett, 84, Michigan, at 408-269. NW2D. That backs up what I just said as well. Okay. They're definitely violating my constitutional rights. This is all arbitratable. Okay. Miss Arnold, when she read that paragraph, looked right dead in my eyes and shut the book. And then laughed at me the rest of the time when Miss Brown was lying about this. See, this case has been postponed out for 2 months while they get their transcripts and all their videos in order. None of it's been done. None of it. Okay.
Well, Mr. Scruggs, I'll just interrupt you only to say that the transcript has been prepared. They're in the court file.
Excellent. Have you watched a video of that or however they do that? Because I'm sure it's on video.
I've not watched a video of anything. I don't review evidence in the case until we have a trial. or
Okay.
I have a motion put before me to request me to review some evidence and make a decision about it in some way. So,
I was under the, I apologize. I was under the impression that that's why I sat in jail for 2 months. Okay, my dad has dementia. He's kind of like comes and goes. And I'm dealing with that, and there's a lot of things that are going on in my life that's, you know what I mean? And with me sitting in here is just nuts.
okay, so, so the way to get through that, I mean, you're asserting, as I understand it, a speedy trial right. And I'm absolutely able to set a trial for my first available opportunity today. So Ms. Arnold, how many days, well, I guess first, are we trying, are any of these going to be consolidated, or do these need to be tried separately?
Tried separately.
Wait, I think so the carjacking is the one it makes sense to try first. And for that particular case, evidence of Mr. Scroggins' slight or trying to avoid prosecution would be admissible. So the R&O case, sorry, I'm trying to do this on the computer. The case with the 2 R&Os, I believe, would be able to be joined with that for trial. That's when he resisted arrest.
I would disagree. I would disagree with
Okay,
that.
Mr. Glazer, can I just ask, let Ms. Arnold finish. I'll give you an opportunity to speak about your disagreement, but I can't understand what people are saying when I've got 2 people talking at the same time, and we can't make a record of it when 2 people talk at the same time. So Ms. Arnold is indicating that you think filing in 416 and 417 can be consolidated. Mr. Glazer has indicated he disagrees. So Ms. Arnold, if you want to do that, I'm going to ask you to file a motion, and I'll hear the motion on consolidation, and I'll make a decision.
Yep, I think that would be appropriate, Your Honor. We're happy to do that.
They were done at 2 completely separate times, Your Honor.
All right, Mr. Scroggins, there's going to be a motion. I'll hear the motion at the appropriate time, but it's not the appropriate time right now to argue that.
And Judge, if the court wants to set the FC for trial, keeping in mind we might be adding that FH, I think we could set it for a 2-day trial now, and then decide the consolidation issue in the meantime.
All right, so the lower case number would be the 1-5 case. That's the possession of methamphetamine, tampering with evidence in an R&O. Is there any objection?
I would ask that we not try that one first, because the carjacking and the R&O cases, the carjacking is the A felony. That's the one that guidelines are for substantial prison. So I think we should try that one. And I understand the people's position. I'm trying to understand from the defense at this point whether there's an objection to that.
There is an objection, Your Honor. We'd ask to take them in the order, the oldest back to the other one, to the most recent.
All right, what's the basis of that objection?
What is the basis of it? That's the way the court normally does it. I guess we're objecting to
the court has the ability to create its schedule in the way that is most efficient in the court's eyes. So why is it that you don't want to try the 415 case first?
The 415 case is the possession of cocaine or
possession of methamphetamine.
I was never in possession of methamphetamine or any drugs. First off,
no one.
You guys are accusing me of things that.
I've muted Mr. Scroggins' device because he's trying to argue the facts of the case, and I'm just trying to understand which trial I'm going to set first. And so he's being disruptive.
Judge, if I can make a suggestion, my suggestion.
Ms. Arnold, not now. I want to hear from Mr. Glazier about why he believes the 415 case should be set first.
Well, Your Honor, I guess I don't see any reason why it should not be. She wants to try another case, hoping that she can get a conviction and then just the other ones will fall away. Well, the same thing could happen the other way around. In this case, if he gets found not guilty and they believe that the police department is lying or not accurate in some of these things, it could be to his benefit. And she may want to reduce or dismiss other cases. So I guess, you know, I don't see why one has to be in front of the other, but I'm going to leave it up to Your Honor. Do whatever you want, please.
All right. So Ms. Arnold, why is it that you want or need to try the other two cases before the 415 case?
Judge, the carjacking case is the one that carries the most substantial penalty. If there's a conviction in that file, we may end up dismissing the 415 case. It would run, I think he was not out on bond on that. So I think it would run concurrent as a matter of law. So I think it makes sense. And I would suggest too to the court, one thing we could do is we could give Mr. Scroggins a personal bond on that 415 case and keep the bonds as is in 416 and 417. So there's not a speedy trial issued based on the dates of the complaints. But I think he was arraigned on all of them at the same time, I believe. Yeah, they all went to exam the same date. So he was arraigned on all at the same time.
I, of course, disagree, Your Honor, that giving a guy a PR bond on one and then leaving bond on all the other ones somehow eliminates a speedy trial date. He's still in jail. It's just a trick by the, you know. It's an illusion.
I understand your position.
Yeah, any concern about his detention would be the same in all three files, regardless of date, because he's been in jail the same length of time on all three, is my understanding.
All right, so I appreciate the fact that the prosecutor may decide to dismiss the lesser case that was filed first if he were to be convicted in the later cases that would have more serious potential penalties. But I don't see, I don't see that under these circumstances as a significant enough reason to rearrange the normal order that the court would try the cases in. So my intent would be to try them in the order that they were filed, beginning with the 415 case. So Ms. Arnold, how much time do you need to, how many days of court time do you need to try that case?
I would say a day or a day and a half.
Mr. Glazier, you in agreement with that in terms of a time frame?
I agree that is at least, there's going to be some lab people she has to bring in, and so it may be closer to 2 days.
All right, Ms. Clark, can you let us know the first available 2-day jury trial date that we have?
Yes, Judge. Tuesday, November 21st at 9 a.m. and Wednesday, November 22nd at 10:30 a.m.
That's good for me, Judge.
Did you say November 21st at 8:30?
9
It would be 9 first.
9 o'clock? Okay. And then the 22nd, the same time?
22nd would be 10:30 because that's a Wednesday.
Okay. Yeah, those are fine, Your Honor. That's the first one's my birthday, so you guys are gonna have to bring in a cake for that.
All right. So how about a final pretrial on November 15th at 8:15.
That's good.
That's fine, Your Honor.
Okay, it probably makes sense to set the other dates now so that, you know, if we wait until November, it's just another 60 days that we're going to be dealing with the court schedule. So, Ms. Arnold, how much time do you anticipate needing for the FC case?
I would say 2 days.
Mr. Glazer, is 2 days sufficient in your mind for that case?
Is that the resisting and opposing?
That's the carjacking. That's the carjacking case.
Yeah, that's gonna take 2 or 3 days.
Okay, so we're gonna need, Ms. Clark, let's go with a 3-day jury trial date. It'll have to be a new panel, so we'll need to look in January.
Tuesday, January 23rd at 9 a.m., January 24th at 10:30 a.m., and January 25th at 9 a.m.
That's good for us, Judge.
There is nothing just in this county at all. You guys don't even know what justice stands for.
What were those dates again, Your Honor?
January 23rd, 24th, and 25th.
Yeah, those will work.
So let's do a final pretrial for that case on January 17th.
Okay.
I will hold off on setting a trial date for the 417 case pending the resolution of the motion to consolidate. I'm not sure if Mr. Scroggins is still there or not. He's not in front of the camera. Mr. Glazer, Ms. Arnold, is there anything else we need to address today?
No, thank you, Your Honor.
Yeah, and the only other thing I probably will do is when I get a motion to consolidate, I'm also going to file a motion to dismiss, and I forget how many of the files, but on the basis of violating the 12-day rule. I've explained to my client that even if I were successful on those, they would probably just turn around and rearrest them, but he wants me to file those. And now that I have the transcript, I will.
Judge, what is the 12-day rule?
14 day, excuse me. He was not, the preliminary exam was adjourned out past the 14 days without any reason given by the court, other than I think maybe the judge was on vacation, but there's a record of it down in district court.
Okay. 21 days.
All right. I guess what I'll ask is that if we're gonna have 2 motion hearings, if you would contact the court and find sometime other than a Wednesday morning. I'd rather not try to do that in the middle of a bunch of pretrials and arraignments.
That's fine. If Miss, I hate to do it this way, but if Miss Arnold would get the date, well, we could set them for the same day is what I'm thinking.
Yep. Sounds good.
Yeah, just let Francis know. I mean, it sounds to me like you'll need maybe a half hour or 45 minutes.
Okay.
All right.
Okay, just for the record, Mr. Scroggins has not come back in front of the camera. I presume at this point that he has left the Zoom.
Just for Miss Arnold's benefit, that's how old I am. It used to be 12 days was the, that's why I still call it the 12-day rule. I know the time has changed at it.
All right, sounds good. Thanks, Judge.
Okay, all right, thank you then. We are all set with this case. Kelly, can you call for file choke?
Kind of choked in a room for the judge, please. Thank you. No, next.
I'll just put for pretrial. Pretrial on the same date as the. Yeah.
Your Honor, is there another White Eagle file?
There is. We're calling one person at the jail right now, and then I'll do Mr. White Eagle after that.
Okay, I just wanted to make sure that there were two of them.
Yeah. Okay, so you're Mr. Choate?
Yes, sir.
All right, Mr. Malero, you need a breakout session with Mr. Choate?
I do, Your Honor.
All right, one moment. Okay, Mr. Dager Margosian, you're back for for Alexander Lee or McGee.
Yes, Your Honor.
He is not logged in. Have you had any communication with him?
I have, so I'm a little curious as to why he's not here. Let me, if I can, just let me try to contact him.
Yeah, sure.
Judge, I noticed Mr. Daly's logged out. Did we already do something with Mr. Adams?
Mr. Daly is still there.
Oh, I see him. I'm sorry. Okay, I thought he was down. I'm sorry.
We have not done Mr. Adams yet. I just haven't had a chance to get to him.
Nope,
Jail.
not a problem. I just wanted to check. No rush.
Your Honor.
Yes.
I tried calling his phone. It went straight to voicemail. He's usually been in contact with me. He's a young kid with no offenses on his record. He's eligible for HIDA. The plan was to take a plea to HIDA today. We waived the exam. I guess I would be asking for, if the court is calling the case now, I'd be asking for maybe an adjournment / show cause rather than a bench warrant.
I mean, I can wait some additional time if you think he might.
I talked with him as early as this morning, so
okay.
It's up to the court's discretion. Whatever we want to do, it's fine. I will say that he was somewhat apprehensive about the Zoom situation when I last talked with him, so I don't know if that's playing a factor here.
Right. Just a moment here. All right, we are on the record. Sorry. Now we have Mr. Choate. So we're on the record in file 23-21381-FH and 23-21435-FH, People versus Kyle James Choate. We are here today for pretrial conferences. In both of those cases, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on record. Ms. Mir, are you appearing on this one?
Yes, sorry. Evening, Mayor, the people.
Salvatore Malero on behalf of Kyle Cho.
All right, Mr. Malero, where do we stand with Mr. Choate's cases today?
Judge, we're trying to work towards resolution, but rather than keep adjourning this, I'd like to set the matter, the oldest case for trial.
The older one would be the 381 case, which are 2 weapons, 1, 2, 3, 4 weapons charges and a fleeing charge. Ms. Mir, how many days are needed for that case, do you think?
This was actually Miss Wagner's file, so let me take a look. She did say something about drug court, though. He was accepted in a drug court. Is that not what you want to do, Mr. Malaro?
We had him screened. The note says he was denied. And I don't
Oh,
know
okay.
why.
Our note said he was accepted. I'm sorry.
Oh, well.
Well, either way, for trial on this, looking at the witness list, I would say maybe 1 day.
Can I say something? Mr. Choate, I'll find out what the discrepancy is. If you've been accepted to drug court, we will get this resolved, okay?
Well, if I'm accepted to drug court, we don't need to set it for trial, do we?
Well, my note, the note I have says you are not.
Okay, so what I'll do, we'll set it for trial. If it turns out he was accepted to drug court, you can still pursue that and enter a plea and do it that way, and we'll just cancel the trial date.
Yeah.
I think that's given that the case is about 90 days old at this point. I think that's the better way to proceed, because I don't want to wait another 4 weeks and then find out we have to set it for trial, and then we just wasted that time. So.
And if I may, Mr. Choate, if you've been accepted, we will bring you into court sooner than later. I'm sure the judge will work with us.
Yeah, if that works out, I mean, we will find a time to get that plea in so that we can get moving forward in that direction. All right, so Ms. Clark, we're going to need a 1-day jury trial date.
If I have Ms. Clark's books, is Bo Parker incarcerated?
No, he's not.
So we could do this and take precedence over Bo Parker on either Wednesday, December 6th or Thursday, December 7th.
Either one's fine.
Well, the only thing I worry about is we've already bumped Bo one time for another trial. But I guess it's up to the judge.
That has been one that's lingered a long time. Is there maybe something else we could look at, Ms. McGreen?
Yep. So our next available then would be Thursday, December 21st.
Wow. Can I speak?
What is it, Mr. Choate?
I've already been in here, Your Honor, over 4 months, 5 months. Can't they figure out if I was accepted to drug court so I can take a plea today, as opposed to sitting all the way till December and then figuring it out then?
If you've been accepted to drug court, we'll get your plea in as soon as we can. So I'm not going to make you wait until that date to enter your plea if you've been accepted to drug court. If that's the case, we'll find a time within the next several days for you to get back and enter a plea so that you can go forward with that. Again, I just want to have a trial date on the books so we don't have to set another pretrial to come back in 2 or 3 weeks to find out that in fact you hadn't, and then be setting a trial at that time, in which case we'd be looking into January for a trial date. So I'm trying to get the trial date on the books now so that we have it if we need it. If we don't need it, we'll get your plea in and get you moving forward with drug court well before December. All right, so we'll set the trial for December 21st at 9 a.m. The final, I'm sorry. December 21st at 9 a.m. with a final pretrial on December 13th at 8:15. Again, if it turns out that Mr. Choate has been accepted to drug court, Mr. Malero, Ms. Muir, you can contact us and we'll get him in at the first opportunity that we have 15 minutes or so to get that plea entered.
Thank you, Judge.
All right, Mr. Choate, you can let the officer that's with you know that you are done with court for today. Yeah, we'll set the other file for a pretrial on December 13th.
So judge trial is the 21st then?
Correct.
All right, thank you.
Yeah.
Okay. Can you, Mr. White?
John. Thank you. Bye.
Mr. Glazier, do you need a breakout session with Mr. White Eagle?
Yes, just briefly, Your Honor.
Mr. Malero, do you have any other cases this morning?
You know, Judge, I honestly don't know. If you want to kick me out, I'll go. I'll gladly go.
You're welcome to stay as long as you want. I don't see your name on our docket for any other cases, so just.
All right, well, I'll enjoy the show. Thanks.
Okay. Mr. Dagger Margosian on Mr. McGee. Well, I guess let's go on the record with Mr. McGee. Okay, so we're on the record in file 23-21513-FH, Alexander of People versus Alexander Lee McGee. We're here today for arraignment in this case. We're proceeding by video conference. First, let me have the attorneys place their appearances on the record.
E.B. Mayor on behalf of the people.
Your Honor, Michael Dagger Margosian for McGee.
Mr. Dagger Margosian, your audio was garbled there for some reason. Could you try that again?
Michael Dagger Margosian for Mr. McGee.
Thank you. So the record should reflect this was set for an arraignment this morning at 8:15 a.m. Mr. McGee is not logged into our Zoom session. He has not appeared at any time in the Zoom session, nor is he present here in the courtroom. I have had some conversation with Mr. Dagger Margosian off the record about that. Mr. Dagger Margosian, is there anything you want to say with respect to Mr. McGee at this point?
Well, I guess I'll just reiterate that we waived the exam in the anticipation of entering a plea to this case. He and his family are invested in this matter. He's given me no indication that he's any sort of flight risk or not invested in this case. As I told the court, he's a young individual. This is the first time in this case that we'd be dealing with Zoom. He had some apprehension about Zoom. I think there probably certainly are times where if an individual doesn't show up, a bench warrant is appropriate. There probably also are times where a show cause / adjournment of the court date would make sense too. I would be asking for the latter, just with those representations here.
All right, Amir, anything you'd like to say from the people's standpoint?
Judge, the only thing I'll add is that Mr. McGee doesn't have a criminal history. The only thing he really has is some not a great traffic record or driving record. And these are traffic offenses. Well, they've stemmed from traffic offenses, although they are more criminal. That being said, I'll leave it in the discretion of the court, but I have no objection to giving Mr. McGee kind of a chance on this as well.
What I will do is adjourn this then to next week, September 20th at 8:15. Not at this point going to issue a bench warrant or a show cause. However, I would treat this as a first failure to appear, so that if Mr. McGee does not appear next Wednesday, that would be a second failure to appear, and he would not at that point be entitled to any grace period before I issue a bench warrant, and I would issue a bench warrant if he does not appear next Wednesday.
Thank you, Honor.
Okay, thank you. No, Mr. Murphy is not here. Okay, we're on the record in file 23-21423-FH People versus John F. Kennedy White Eagle. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Muir.
E.B. Mayor, on behalf of the people.
John Glazier on behalf of Mr. White Eagle.
Okay, Mr. Glazier, where do we stand with Mr. White Eagle's case today?
Your Honor, Mr. White Eagle is going to plead to, what is it, PB? Just the count one, or is there no sup on it?
It should just be account one, no sub. Yeah, just possession of meth, judge, without the drug sub.
So it'd be a 10-year felony. And there would be a killabrew, Your Honor, that Mr. White Eagle would be released after sentencing. There wouldn't be any further jail after sentencing. But if he violated his probation, obviously he could face, some serious time, probably prison if he violates it. And he understands that.
That's correct, Your Honor.
Okay. So the habituals are being dismissed as well?
That's correct.
Okay. Mr. White Eagle, would you raise your right hand, please? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
You are John F. Kennedy White Eagle?
Yes, sir, I am.
Mr. White Eagle, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, possession of methamphetamine or ecstasy?
Yes, sir, I do.
Are you satisfied with Mr. Glazier and the advice he's given you?
Yes, sir, I am.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. Muir?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. White Eagle?
Yeah, yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. White Eagle, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, I understand that.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, no, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about April 2nd, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine?
Yeah, I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty?
No.
Do you understand if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that weren't disclosed on the record this morning, or that it wasn't your own choice to enter the plea?
Yes, I understand them.
So prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. White Eagle to plead guilty?
None, Your Honor.
Mr. Glazier?
Yeah. No, Your Honor.
Mr. White Eagle, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record this morning?
No.
Is it your own choice to plead guilty?
Yes.
All right, Mr. Glazier, do you want to establish the factual basis?
Yeah, Mr. White Eagle, you understand that you've pled guilty to possession of meth, which carries a 10-year maximum sentence?
Yes.
The prosecutor has made an agreement that at sentencing, when you get sentenced, that you won't do any further jail, that you would be released at that point, but you would be on probation. Do you understand that?
Yes, sir, I do.
Now, if the judge gets has a different opinion and is going to give you more jail, or if he was going to send you to prison, you would have a right to withdraw your plea. Do you understand that?
Yes, sir.
All right. If you get put on the reason we're not doing screening you for drug court, because you've already tried and failed at drug court once, haven't you?
Yes.
So you understand if you're going to be, if it works out like I've told you, what'll happen is you'll be on probation. But if you can't, if you keep doing drugs, you're going to get violated and you could actually get sent to prison at some point. Do you understand that?
Yes, I understand that.
Okay. On April 2nd of 2023, you got pulled over by the police. Is that correct?
Yes, sir.
And that was here in Lenawee County in the state of Michigan. Is that true?
Yes.
And when the police pulled you over, they took your keys and it had a little packet or something on it, didn't it?
Yes.
And inside that was some methamphetamine. Is that correct?
Yes.
And those were your keys and that was your methamphetamine and you knew it was methamphetamine. Is that true?
Yes.
I don't have any other questions, Your Honor.
Ms. Muir.
I'm satisfied with the factual basis.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Glazer?
Yeah, it has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. White Eagle has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation, or the court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for November 2nd at 8:15 a.m. Mr. White Eagle, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
All right, I will continue bond as it's currently set. Mr. White Eagle, you can let the officer that's with you know that you are done with court for today. Other than I am going to sign an order for fingerprints. It doesn't appear that we have fingerprint information in the file. So we're going to need to have them fingerprinted before the sentencing date.
Okay. Thank you.
All right. Thank you very much, sir.
Have a good day, everyone.
Thank you, Your Honor. That's all I have with you this morning.
All right. Thank you, Mr. Glazer.
Yep, we'll see you later.
Mr. Adams.
Could we have Jason Adams in a room for you, please? Thank you.
Nice.
Over here, we're closing.
Okay, Mr. Daly, do you need a breakout session with Mr. Adams? You are muted, Mr. Daly.
No, Your Honor.
Okay, we are on the record in file 23-21392-FH, People versus Jason Michael Adams. We are here today for an arraignment, no, a pretrial hearing in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record.
E.B. Mayor on behalf of the people.
James Daly on behalf of the defendant.
And Mr. Daly, where do we stand with Mr. Adams' case today?
Your Honor, we have a resolution of this matter. If Mr. Adams pleads guilty on file number 23-21392 FH, concealing the death of an individual with 2 subs, there's been an agreed upon guideline range of 19 to 47 months. In addition to that, on file 23-21294 FH, plead to the possession of meth, and on file 23-21293 FH, again plead to the possession of meth and dismiss the controlled substance and habitual. And on file 211797, dismiss the retail fraud but admit for restitution. And the prosecutor's office has agreed to a concurrent sentencing guidelines range of 19 to 47 months.
Okay, I guess first let me ask Ms. Mears, is that a complete and accurate statement of the plea agreement?
Yes, Your Honor.
All right, so for some reason I only have one of the cases on the docket this morning. Can you tell me again what those other case files were?
Yes, the case files are on, it's be 23-21392 FH and 23-21294 FH, and then 23-21293 FH, and 211797 SM. Those are the files that I have.
So that one's a district court one, so I don't need to worry about that. Okay, and so in the 392, he's pleading to the only count, which is concealing the death of an individual.
That's correct.
With a habitual second offense notice, Your Honor.
Two subs on that one.
Yeah, sorry, second offense.
Or I'm sorry, if it's 2 subs, it'd be habitual third offense. Yeah, I apologize.
Okay.
But yes, that is what I had estimated those guidelines to be.
Okay, and then in 294, what was he pleading to in that case?
Possession of meth.
And which count is that?
21294.
Which count on the information is that?
I'm pulling it up right now. It would be count 1 without the drug sub.
Okay. And then the 293 case, what is he pleading to in that one?
Possession of meth.
So it looks like that's count one on that one as well. All right, then I did not call the other cases, so we're also on the record at this point in file 23-21392-FH, 23-21294-FH, and 23-21293-FH. Okay, so Mr. Adams, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor. Yes.
And you are Jason Michael Adams?
Yes, Your Honor.
Mr. Adams, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 23-21392-FH to count one, concealing the death of an individual?
Yes, Your Honor.
You understand the maximum penalty for that offense is 5 years in prison?
Yes, Your Honor.
Is it your intention to plead guilty in file 23-21293-FH to count one, possession of methamphetamine?
Yes, Your Honor.
You understand the maximum penalty for that offense is 10 years in prison?
Yes, Your Honor.
And is it your intention to plead guilty today in file 23-21294-FH to count one, possession of methamphetamine?
Yes.
Understand again that maximum penalty for that offense is 10 years in prison.
Yes, Your Honor.
And I apologize, I need to correct something I said about file number 23-21392-FH. That's the concealing the death of an individual. Is it also your intention to plead to or admit the habitual offender third offense notice?
Yes, Your Honor.
All right, and I'm sorry, Ms. Muir, I don't have that in front of me. What does that do to the maximum penalty?
Let's see, a habitual third, I believe takes it up to a 15-year, but let me double check. Second, third. I'm sorry, it's twice. So twice the maximum, so it'd be a 10-year.
Okay. All right. So Mr. Adams, I previously indicated to you that the maximum penalty for concealing the death of an individual is 5 years. Because of the third offense notice, the maximum penalty in your case would be 10 years for that offense. Do you understand that?
Yes, Your Honor.
Are you satisfied with Mr. Daly and the advice that he's given you?
Yes, Your Honor.
Other than as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Mr. Daly?
Yes, Your Honor.
Is that also your understanding, Mr. Adams?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. That means you'll be giving up the evidence, the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Adams, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. You have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about May 15, 2022 in Palmyra Township, Lenawee County, Michigan, that you commit the offense of concealing the death of an individual?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about May 10, 2022 in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine?
Guilty, Your Honor.
And how do you wish to plead in file 23-21294-FH that on or about October 4th, 2022 in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
You understand that if I accept your plea, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Adams to plead guilty?
None, Your Honor.
Your Honor.
Mr. Adams, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes.
Mr. Daly, would you like to establish the factual basis?
I would, Your Honor. Mr. Adams, is it correct on May 15th in the year 2022 that you were in the presence of an individual by the name of Alexis Lutz?
Mr. Adams, were you able to hear that?
Yes.
Okay, did you understand the question?
I heard it cut out towards the end, but yeah.
Okay.
On May 15th of 2022, were you with an individual by the name of Alexis Lutz?
Yes.
And in that time period, did she die?
Yes.
And after she died, did you report that death or take her body to the proper authorities or to a funeral home?
No.
All right. As it relates to
Well, do you want to finish this factual basis first?
okay.
Oh.
All right. Yeah.
Go ahead.
Go ahead.
The only thing I was going to add is mostly for guideline purposes, but also factual basis purposes. Do you agree that if you had gotten Miss Lutz any sort of aid that she may not have died?
Yeah.
Okay, thank you. And that was in Palmyra Township in Lenawee County?
Yeah.
Okay. And Mr. Daly, do you want me to ask the questions as it relates to the habitual offender?
That's fine.
Okay. Mr. Adams, do you agree that you were convicted on or about April 1st, 2019 of a felony, that being failure to comply with the sex offender registration in Iosco County in Michigan?
Yeah.
Okay. And then do you also agree that you were convicted on or about June 12th, 2008 of a another felony, that being a criminal sexual conduct second degree in Washtenaw County.
Yeah.
Okay, I'm satisfied with the factual basis, Your Honor.
All right, so let's move then to the next file.
On file okay, 2321293 FH. On May 10th of 1922, were you in the possession of a controlled substance, methamphetamine?
Yes.
Okay.
Just sorry to interrupt, just with the record, I believe you meant 2022.
I'm sorry, 2022.
Yeah.
Yes.
And were you in possession of methamphetamines?
Yes, I was.
And that was in the county of Lenawee County?
Yes.
Okay. And you had no permission to possess that, is that correct?
Yes.
I believe we've established the factual basis to that one, Your Honor.
Okay, Ms. Muir, any follow-up questions on that one?
No, thank you.
Okay.
This is the district court case. I don't think we have to do anything with that one, do we, Judge?
Correct.
All right. Oh, and we have file 22224. Oh, that's the district court case. I'll move on to on December 21st, 2021. Did you commit a retail fraud? I'm sorry. Did you commit a retail fraud in Lenawee County?
Yes.
And did you steal property that was offered for sale at a price of less than $200?
Yes, I did.
And that was also in Lenawee County, Michigan?
Yes, it was.
I have no other questions of this one, Your Honor.
I'm satisfied, Your Honor.
I
believe that concludes what we had, Your Honor.
I'm sorry, I thought he was pleading to possession of methamphetamine in both of the other two felony files, right?
He is.
All right, so we've covered both the May 10 possession and the October 4.
Correct.
I believe so.
All right, sorry, I apologize. It's been a long morning. All right then. Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Daly?
Yes, Your Honor.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Adams has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record this morning. I am referring this matter to the probation department for a pre-sentence investigation. And we will set sentencing for November 3rd at 8:15 a.m. Mr. Adams, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
All right, I will continue bond as it's currently set then, and we will see you back for sentencing on November 3rd.
All right, thank you, Your Honor.
Okay, thank you, sir. No, they just put that on the record for purposes of restitution. I think they're going to dismiss that. Okay.
Judge, do you need amended information on the habitual third for that? Or is it just something we do at sentencing?
I think we do that as sentencing fee.
You know what, I will, I don't know the answer to that question off the top of my head, but I will ask around and figure it out. And if we need an amendment information, we'll let you know.
Okay, thank you.
Okay. All right, Mr. Daly, I think that's all I had for you, unless I missed something.
I had Bixler, Your Honor.
You have a case number there? I don't have that. I have Bixler on my docket.
If it's not on your docket, Judge, I'm fine with that. There's no really, we're just prepared to go to trial, but I had it in my docket. I have nothing else.
Okay. All right, I think we're all set then.
Thank you, Your Honor.
Thank you. And then Mr. Murphy.
Yes, Your Honor.
So we can start the record for Greg. We're on the record in file 23-21514-FH People versus Gerald Thomas Grayer. We are here today for a pretrial conference in this case. They're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
Phoebe Muir on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Grayer. And Your Honor, today is the date scheduled for the arraignment. I'm sorry, it's not a pretrial. And I wanted to explain that's the reason why he's not here is in district court. I advised him I was intending to waive his arraignment, but I forgot and neglected to do that. I've tried to reach him this morning, but the number I have for him is not correct. The person who answered said that that's not his number. Again, I had told him I was going to waive it. This is my fault that he's not here. He would be there in person if he was aware of it, that it was going on. So I would ask the court if we could possibly reschedule this a week or two, whatever fits the court schedule best. Because I told him to contact my office by the end of this week. So I'm hoping he does by Friday and we can get this readdressed. I do apologize, Your Honor, though, for his non-appearance.
Okay, Ms. Muir, anything we need to address from the people's side?
No, I don't believe so, Your Honor. Just leave it in the discretion of the court.
All right, so what I'll do is adjourn the arraignment to next week, September 20th at 8:15. If we can get a waiver, before that, obviously we can take it off, but otherwise we'll proceed at that time.
Yes, Your Honor. Thank you.
Okay, thank you very much. I think, Ms. Muir, that is everything that I had for today.
That's it. Thank you. Sorry, this morning was a lot.
No, not your fault.
Great.
Thank you, Your Honor. You have a good
day.
Have a good day. Thanks.